In January 2019, the National Information Technology Development Agency came up with a subsidiary law leveraging on its mandate and power as in Section 6, Article A of NIDA Act 2007. The subsidiary law has been entitled as Nigeria Data Protection Regulation. The wisdom behind coming up with this regulation is to ensure the privacy and confidentiality of our data that we are submitting to government and other private institutions. Confidentiality of our data and security of our data is key to whatever we do. In some cases, you will discover that some institutions are abusing the data of citizens they collect. Some they will even advertise data online. Some they even commercialize without the knowledge of our citizens. At that time, the National Information Technology Development Agency, leveraging on Section 6 of NIDA Act 2007, came up with a subsidiary legislation or subsidiary law. That law has been enforced by the Commission. And we did so at the time that the European countries collectively came up with their General Data Protection Regulation, that is the EU Data Protection Regulation. And it becomes even part and parcel of the global best practice in security, in economy, in whatever your country does with other countries. To the extent that today, potential investors usually ask questions. When you invite them to invest in your country, they will say, do you have any data protection law in place? So that they will ensure data to be collected is going to be protected. In February 2022, His Excellency President Muhammad Buhari has approved the establishment of the Nigeria Data Protection Bureau, and he also approved the appointment of Dr. Vincent Olatunji, the then Director of E-Government in NIDA, to be the National Commissioner. After enforcing the law, we also discover there is need for the integration of the subsidiary legislation into a principal legislation. We must have a principal law in place. In Nigeria, subsidiary legislation could be as powerful as the principal legislation, or it could be as powerful near to the principal legislation because it is being considered up to the Supreme Court as a law, as long as the rule-making process is respected. However, when dealing with international communities, some of them do not recognize your subsidiary law as a law. You must have a principal law that will go to the National Assembly. It is because of this, with the support of the Office of the Minister of Justice and other stakeholders, we integrated the subsidiary legislation by addressing some observations that have to do with lacuna and certain vacuums. And it has been presented today before the Federal Executive Council, and it has also been approved, and the Attorney General and the Minister of Justice has been directed to transmit the bill to the National Assembly.